Bernardino County School Board Association is proud to partner with San Bernardino County Superintendent of Schools and the Inland Personnel Council to bring you this series of workshops on effective boardmanship. Hello, I am Mary Sandoval, your County Association President and an active board member for Fontana Unified School District. Tonight, we'll be learning about the Ralph M. Brown Act. The Brown Act, enacted in 1953, helped ensure that the important work of public school governance is conducted openly and transparently. Meeting requirements for all California city and county government agencies, boards, and councils are in place to guard against backroom deals. There are a few exceptions which allow school boards to meet behind closed doors, but even then, safeguards are supposed to be in place. Ignoring these rules can lead to consequences based on the severity of the violation. Joining us for this incredibly important session are two veteran attorneys who will cover Brown Act basics, plus give practical tips on some do's and don'ts regarding social media.
Good evening. I'm Ted Alejandre, your San Bernardino County Superintendent of Schools. Welcome to the third installment of the Effective Boardmanship Workshops. I'm holding a gavel, which is a tool and a symbol that school boards use to convene meetings and conduct business. The Open Meeting Law, or Brown Act, has requirements that may not sound exciting at first, but is one of those topics that carries an important duty for all board members to follow. We have two top-notch attorneys here to guide us through the process, courtesy of our partners at the Inland Personnel Council through Atkinson, Andelson, Loya, Rude, and Romo. The two attorneys joining us tonight, Paul McLaughlin and Beverly Ozuwara, bring a wealth of experience in school law. With that, let me turn the session over to our attorneys for their presentation.
Good evening, everyone, and welcome. My name is Paul McLaughlin. I'm a partner with the law firm of Atkinson, Andelson, Loya, Rude, and Romo. I've been with the firm since about 2008. During that entire time, I've worked with many different school districts, county offices of education, and community college districts. I currently work out of the Pasadena office. I've practiced exclusively school and community college district law for my entire career. And I have worked with a lot of different clients here in the Inland Empire. Happy to be here this evening. And with me I have Beverly.
Good evening, everyone. My name is Beverly Ozuwara. I'm a senior associate out of our Riverside office. I've been with the firm for a few years and was previously a litigator before joining the firm. Happy to be with everyone this evening.
Okay, so tonight as part of our Boardsmanship series, we're going to be going over the Brown Act. What you don't know can hurt you. First, before I jump into it, actually, just have to give just a quick disclaimer. We do this with all of our presentations, but basically what we're saying tonight is that don't rely on this solely for legal advice. We're here to give kind of tips and tricks and give you the background on what the Brown Act entails. As part of this, if you ever have any questions, we do encourage you to reach out to your legal counsel on any specific issues that you might have. So that's the disclaimer part of it. We can move on. So tonight's agenda, we're going to go through several different aspects of what the Brown Act entails. First of all, first and foremost, what is a meeting? The Brown Act essentially says that we cannot, as a board, be conducting business outside of a noticed public meeting. We have a majority of our members together discussing business. That constitutes a meeting. So what do we have to be doing within the confines of the Brown Act in order to ensure that we're not having any sort of meeting that is in violation? So we're going to be spending some time about what a meeting entails. Thereafter, we're going to be going through a serial meeting exercise. And what's a serial meeting? A serial meeting is essentially a series of communications amongst board members that ends up touching a majority of the board. At that point, a serial meeting has occurred, and if you haven't had any sort of noticed agenda, then that's technically a Brown Act. It's technically a meeting that's occurred outside of the Brown Act. So what we're going to do is we're going to go through a series of exercises to show what constitutes a serial meeting. Sometimes people get surprised by that content. A lot of these conversations also occur via email, casually at dinner. So there's going to be different scenarios to keep in mind when we're talking about a serial meeting. Next, we're going to be talking about meeting conduct. So there are some specific rules, not just in your board bylaws, but under the Brown Act that you have to be following in order to conduct your meeting. So we're going to be touching upon some of the major ones and the ones that come up most often, including things like public comment, and hopefully you'll be able to keep these things in mind as you're moving through your meeting to help both run an efficient meeting, but also a meeting that complies with the law. Next, we're going to be talking about agendas. What do we need to be including on an agenda? Basically, our baseline rule is that people need to have an agenda item that reasonably apprises the public of the business to be conducted. So we're going to go through some ins and outs about what needs to be on an agenda, what should be on an agenda, and other items of business that we need to be talking about in a way that complies with the Brown Act. Next, closed sessions. Closed sessions tends to be one of those items where we get a lot of challenges, to be frank. People think that closed sessions, we can talk about anything and everything at a closed session. However, there's very specific rules about what you can and can't talk about. There's also very specific rules about what you have to report out after a closed session. So we're going to go over some of those examples based on action taken in closed session, what you need to be reporting out, and also some specific language that you need to be using when talking about your closed session agenda items. Additionally, it's not the most fun thing to talk about, but violations and confidentiality. So there are some repercussions if you violate the Brown Act as a body or as an individual. There are some challenges that people can make through demands to cure and correct. There's also some individual penalties that may arise if you violate confidentiality. So we're going to go through a bit of that, hopefully not too heavy-handed, but just to impress upon everyone the seriousness of what the Brown Act entails and what we need to be keeping confidential in closed session. Then we're going to have a bonus 8 hot topics. We couldn't quite get to 10, but 8 hot topics that here in 2023 that we need to be kind of keeping in mind. Some things that may be helpful, things you didn't know about, that may, think that Brown Act is not so heavy-handed, but also some things to keep in mind. So we're going to be talking about things like social media, teleconferencing, some rules related to negotiations, but these 8 hot topics kind of in 2023, just all things to keep at the forefront of your mind that weren't necessarily relevant even a couple years ago. And then if we have time at the end, we do have some questions, some Q&A that have been generated that we'll be able to discuss and kind of talk through those and figure out some of the hot topics and maybe give you a refresher on some things that you hadn't thought about for a while.
So under the Brown Act, what is a meeting? So a meeting is any gathering of a quorum, so a majority, of a legislative body to discuss or transact district business. So it's important under the Brown Act and just in compliance with the Brown Act to avoid any serial meetings, which Paul had mentioned earlier. But in terms of the meeting requirements, so standing subcommittees, that's okay, but not ad hoc meetings.
So I just wanted to unpack that a little bit because I know that there tends to be maybe a little bit of confusion when we're talking about subcommittees. So a lot of the times as a board, you may have a meeting at the beginning of the year where you establish a standing subcommittee. Maybe you have your policy committee. If they regularly meet something that's established by board action, then that subcommittee, even though it's less than a quorum of your board members, that can be subject to the Brown Act. Versus an ad hoc committee. So an ad hoc committee, just like it sounds, it's a committee that's put together for a particular purpose of limited duration. Really the most common one I think we think of is a superintendent search committee. So if you have an established ad hoc committee that's for the purpose of a superintendent search, if you have less than a quorum of your board members meeting and discussing how to conduct that search, that's not subject to the Brown Act. So that's just a distinction that a lot of our clients like to understand, but it's something that with your standing subcommittees, just keep in mind that you're going to have to be subject to the Brown Act.
And so some exceptions also in terms of the Brown Act, so conferences or meetings that are open to the public, some purely social meetings or ceremonial events, those are exceptions as well. So long as district business is not being discussed at these events, then it's perfectly fine.
Right, and I don't know if you've had the experience, but things like the one that comes up the most often for us is CSBA. You know, you have a majority of your board members at an attendance. You say, you know, what can we be doing and discussing? Can we go out to dinner? Can we attend speaking events together? CSBA is a great place to be able to expand, you know, your knowledge base and talk about, you know, potential ideas, but you do have to be careful in those situations that you're not talking about specific district business. For example, you might attend a session on public housing. I know that's a big one that a lot of our clients are starting to think about. If you attend a session, there's a majority of your board members there listening in, perfectly acceptable. If you start talking about that property off on the corner of Main Street and Grand Avenue as a specific spot to be able to open, you know, potential district housing, that could potentially get you in trouble. So that's what Beverly's talking about when she talks about no discussion of district business at those events.
Right. And in terms of the location of these meetings, so it does need to be open to the public, ADA accessible, and then within the boundaries of the district as well.
So we did put in there that there are a few exceptions. Those really are few and far between, but things like having a meeting to interview a superintendent candidate, for example. You know, we had that one time with the whole board going to the superintendent candidate's current place of business. At that point in time, they were allowed to have a Brown Act meeting, a Brown Act compliant meeting, even though there was a quorum of the board there. So, you know, just another point with the ADA accessibility, that's come up a lot. I don't know if you've had the questions with during COVID with Zoom meetings. You have to be able to have the public basically attend and participate. So you may need things like closed captioning or, you know, something for deaf and hard of hearing folks. But just keep in mind that Brown Act meetings have to be ADA accessible.
In terms of teleconferencing and video conferencing, so one or two members may participate remotely. That's permissible under the Brown Act. But the location and the location of those remote members must be noticed, and the agenda must be posted as well so that it's open and accessible to the public. And during the pandemic, so there was Executive Order, Assembly Bill 361, where all members may participate remotely during a state of emergency if resolution declaring public safety is made. And so public must be allowed to participate and observe telephonically or otherwise electronically if that's going to be done. And then in January of 2023, there was Assembly Bill 2449, which was saying that less than a majority may participate remotely for just cause or if there's an emergency situation that arises. But the main key with all of this is accessibility.
So Beverly, I don't know if did you have a lot of clients using the traditional teleconferencing or video conferencing option prior to the pandemic? I don't know if you worked with a lot.
Not too much.
Yeah, and in those kinds of cases, we got these interesting questions about, you know, if I'm participating remotely, how long do I have to be posting my agenda? Like, where am I posting my agenda? Kind of the one that came up a lot is someone on vacation. You know, do I have to post an agenda outside of my hotel room? And the answer is yes. You know, in those old traditional teleconferencing, video conferencing rules, you could have a member participating remotely, but like Beverly was saying, you have to have the notice posted as if you were having your meeting at that location. So it kind of got a little weird when, you know, you had it in hotel rooms or, you know, someone one time asked me if they could have it on a cruise ship. These things pop up from time to time, but those were the kind of traditional teleconferencing rules. They still apply. You can still absolutely use them. But then AB 361 during the pandemic hit, and that allowed us to have all sorts of different meetings. But I don't know, did you have clients who were taking advantage of that and having to do the emergency resolution over and over?
Some repeat offenders, yes.
Yes. So we had some folks under 361, AB 361. It was a little bit difficult because you had to be constantly every 30 days declaring a state of an emergency. Now that's kind of gone away because, you know, we're no longer in a state of emergency in California, thankfully. But now we do have AB 2449, which allows less than a majority to participate remotely for just cause or an emergency. So we're going to get into that a little bit later during our 8 hot topics. kind of unpacking what that means. But just for clarification, you can still do the old teleconferencing rules, the traditional ones that have always existed. You don't need to worry about AB 361 for now. Next time there's a state of emergency, hopefully 100 years from now, we can reuse it. But think about AB 2449 as a potential way to be having people participate remotely without having to follow the traditional teleconferencing rules. And like I said, we're going to get into that a little bit later in the program. All right, so at the top of the hour, we were talking about serial meetings. So, what is a serial meeting? And here we have right out of the Brown Act, Government Code 54952.2, what the definition of a serial meeting is. So it's a majority of the members of a legislative body cannot, outside of a meeting authorized by this chapter, meaning the Brown Act, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business that is within the subject matter jurisdiction of the legislative body. Now let's unpack that a little bit, because that's just gobbledygook in the legislation. Basically means you cannot have a series of communications amongst different members of your body that results in a majority of the body having a discussion on a particular topic. What we're going to do with this series of exercises is we're going to assume that we have a 7-member board. And when we get to 7 members, we have a majority at 4. So most of you are 5-member boards. So when would we hit a majority at 5? We get 3. So when we're going through this exercise, think about a majority of your board. So all of these examples have a 7-member board, just because it's a little bit easier to show when a serial meeting occurs. But for those of you who are on 5-member boards, remember, once you hit 3 people, you've had a serial meeting, if you're talking about the same subject amongst others. If you have a 3-member board, as soon as you get to 2. So anytime we're talking about a majority of your board having a communication that's a serial communication, that results in a Brown Act violation. So for these purposes, just to make it a little bit easier visually, we're going to use a 7-member board. So with this first serial meeting, say we're talking on the telephone. Board member 1 wants to have some conversations about something on the upcoming agenda, maybe the superintendent's evaluation. So board member 1 calls board member 2, hangs up the phone, they're knowing what they're going to talk about. When do we get to a serial meeting if we're having separate conversations between 1 and other board members?
Based on a 7-member board, that would be at board member 4.
Right, because at that time we've connected 4 minds. So think about when you're connecting minds through these conversations, that's when you get a serial meeting. So with a 7-member board, as soon as we hit 4, that's a violation of the Brown Act. With your 5-member boards, if you hit 3, that's when the violation occurs. So this actually happened to me early in my career where we were going through a teacher layoff. So between 2009, 10, 11, when we were doing a lot of those, we were preparing for the layoff hearing. It was going to happen in a couple of days, and the superintendent came into the room and said, "I have great news. We don't need to go through the layoff. The board's not going to support it." And we all asked, "Well, how do you know that?" And it was because there was a serial meeting that occurred. There were multiple minds that were connected through that. So anytime you hit the majority, that's when you've got a serial meeting. All right, so let's change the scenario up a little bit, and let's talk about these conversations. So we have, again, think about a telephone. So we have board member 1 calling board member 2, and then hanging up and calling board member 3. Now separately, unbeknownst to anyone, board member 5 calls board member 7, and board members 5 and 7 aren't talking to 1, 2, and 3. Have we connected 4 minds at that point? No, we haven't. So although there's these separate conversations occurring, there hasn't been conversations on the same topic amongst multiple people. So you can have separate conversations going on items within jurisdiction. However, where you may get into trouble is you don't know how many people number 1 is called. You don't know how many people number 5 has called in this scenario. So in this particular scenario, 2 different topics, less than a quorum of the board, no Brown Act violation. What happens, though, when we start playing the actual telephone game, where you're having like a telephone tree situation. Someone hangs up the phone and passes it to someone else, and the message gets passed down the line. So that's what we have in this scenario. So say we have board member 1 calling on the telephone and calling board members 2 and 3. At that point, board member 1 says to themselves, oh great, there's no Brown Act violation here because I've not connected enough dots. However, unbeknownst to board member 1, board member 3 calls board member 4 about the same topic. Do you see a problem with that, Beverly?
I am seeing a problem with some meeting of the minds there.
Yeah, so what's the issue?
That board member 1 and 2 are having the same conversation as board members 1, 3, and 3, 4.
Right. So at this point, we're having a conversation on the same topic amongst 4 different people. So 6 and 7, they're having their own separate conversation. Normally that wouldn't be an issue. However, we have 1, 2, 3, and 4 connected at this point because they're sharing the same thoughts. So at this point, they're having a meeting outside of the Brown Act where they've really connected their 4 minds together. So that's just something to keep in mind when you're talking about a serial meeting, is when am I getting enough heads together? I know that sounds a little bit silly, but if I'm on a 5-member board, as soon as I get 3 heads together on the same topic, that is a serial meeting, and that's a violation of the Brown Act. All right, so we've been talking about scenarios where board members are talking to one another. And that's sort of a classic scenario that we think about when we're thinking about serial meetings. But there's other ways to have potential Brown Act violations with other players. And the number one way that we have this is no fault through their own, but our superintendents. Our superintendents, they're the ones who interact with the board most frequently. They're keeping them abreast of situations as they're ongoing. They're the ones who are implementing the board's vision. They're the ones who are basically running the district, for all intents and purposes, as the spokesperson for the board. So we have what are called hub and spoke communications. And that's where you're using an intermediary to communicate amongst board members. So that's where it typically comes up with the superintendent, just as the board's really only employee and the person who's most connected to the board. So in this particular scenario, this is not a serial meeting. And do you know why it's not a serial meeting?
It looks like a superintendent communicating outward, so not a serial meeting.
Right, so that's what's important, is that we have our one-way communications that are going out to the board, just one way. So we use this as our typical Friday memo example. So this is something that's really common occurrence in a lot of your districts. So you have the superintendent sending out the Friday memo to all of your board members. That is perfectly acceptable, because remember our baseline rule is about connecting heads. People are getting information, but they're not talking amongst each other. They're not connecting. So your typical Friday memo situation where you're doing what's called a hub and spoke communication, you think about your superintendent in the middle and the wheel around them. You can have a one-way communication. That's perfectly acceptable. But what happens when you get people starting to respond back? So typically, your Friday memo, that goes out via email. And that is a really easy way to start connecting people and start getting into situations where you're going to have people talking to one another, start having this meeting of the minds. So let's say you have your Friday memo go out. You have a response from, again, we're on a 7-member board. You have a response to the Friday memo with specific questions back to the superintendent. So you have fewer than 4. So that's okay in this scenario because we have less than majority. If this was a 5-member board, if you had 2 people responding, that would be okay. Where you get in trouble is if you have a majority of your folks responding back to the superintendent. That is a hub and spoke communication where you're getting feedback from a majority of the board that's going back to the superintendent. If you're going over a quorum, that's where you can have a Brown Act violation. Have you ever done any Public Records Act requests where this exact scenario has come up?
I have.
Yeah, and what happens in those? And what's happened in your experience?
It's just been a little concerning, looking for if there's that fourth or if there's that majority, with board members not even realizing that each one of them is responding back.
Right, and that's the thing. It's like completely innocent, right? We think about, you're just talking about what's best for kids, right? And people saying, I think XYZ on this particular point. Unfortunately, this is where it comes in with the Brown Act and the Public Records Act, is those are all public documents, right? So it can create situations, especially with email, where you may have a Public Records Act that you're demonstrating a Brown Act violation just by having to produce those records. So just a general tip with the Friday memo is take it as information, just don't respond to it. If you have a really pressing, burning question, and this may be getting into some more like a boardsmanship topic, your board president is really the point person who's communicating with the superintendent regularly about these sorts of things. So just be cognizant if you're getting these communications from your superintendent that you don't reply substantively. You can absolutely reply like, hey, thank you, okay. Or, hey, thank you, see you Tuesday night. But when we're getting into these substantive conversations is where you can get in trouble. All right, so this is a bit of a variation on the hub and spoke communication. So again, we have a 7-member board. We have our Friday memo going out to all of the board members. And at this point, board member 6 goes ahead and starts having conversations with other board members about what's in the Friday memo. So at this point, in this scenario, they've talked to board member 5 and board member 7. What do you think? Do we have a Brown Act violation at this point?
Not at this point, based on a 7-member board.
And why is that?
Because at this point, it's just 2 or 3 total board members communicating.
Right. So again, this is one of those situations like the one before that we had, where we had people responding back. So this is not people responding back to the superintendent. However, these are people talking about something in the Friday memo with one another. So this kind of gets back into that telephone game that we were talking about previously, right? We were having board member 6 who's having conversations with board member 5 and board member 7 about, textbook adoption. The second board member 7 talks to board member 1, we've got a serial communication. So always be keeping in the back of your mind that there may be other conversations going on. Because if there are other conversations going on, if there's a majority of the membership who end up being connected, that's a Brown Act violation. And again, comes up in Public Records Act requests sometimes where you have a series of emails that are going amongst one another. You just may innocently and inadvertently be committing a Brown Act violation. Okay, so what's happening now?
And now we've added one more board member who's connecting the mind.
Poor board member 4, just innocently, inadvertently getting connected with 3 others. So in this scenario, Brown Act violation, right?
Yes.
All right, so we're going to go on a variation with the serial meeting exercise. So here we have the superintendent sending out their Friday memo, okay? So the Friday memo goes out, and board member 6 talks to board member 7 and 5 about this textbook adoption issue. It's a hot topic in the district right now. 3 and 4, they're talking about some athletic field trip or something like that. So at that point, we're not having any Brown Act issues, right?
Correct.
And why is that?
Because it's 2 different topics.
2 different topics. We've got 3 of a 7-member board, so we don't have a majority yet. But what happens when board member 1, he's talking right back to the superintendent about textbook adoption? They're not talking to 5, 6, and 7, but at this point, there's 4 people talking about the same topic. Is that an issue?
Now that's an issue.
Now that's become an issue. So at this point, we've had 4 people talking about the same subject, even though unbeknownst to each other, they're having that conversation. At that point, there's 4 minds that are connected on the same subject. So in our 7-member board, that becomes an issue. If we had a 5-member board, if we had 2 people talking to each other, if 6 and 7 were talking to each other, and 1 was talking with the superintendent, you had 3 people on the same topic, that's a Brown Act violation. All right, so I know that can seem like a bit of a silly exercise, but really it gets kind of the juices flowing about what goes on with serial meetings. So Beverly, what are some keys to safety that we can think about when we're thinking about serial meetings?
Right, so one-way communication from non-board members to the board, that's perfectly fine. So that example we just went through with the superintendent communicating to the board one way, that's fine. Other examples would be legal counsel sending one-way communication out to board members, or even union representatives or community members sending it one way to the board, also okay. However, it's not safe to respond for the board to respond, because any response can accidentally cause a violation, similar to the examples that we went through a few moments ago.
Right. And they don't necessarily have to be talking to each other, right?
Right.
If they're using the same intermediary, talking about the same subject, that's where you get into problems.
Yeah, and so up to 3 board members can communicate. This is based on a 7-member board, but it's essential that each one knows and agrees not to talk to any others. And so if another member attempts to communicate, the member should politely inform them that they cannot discuss this issue due to the Brown Act.
Right. And that one, it might seem a little bit cold-hearted that, I don't want to talk about this with you over email or outside of a meeting. But really, it's just the ultimate safe approach. Sometimes you just will happen to have those conversations. Just be cognizant that other conversations may have occurred on a particular topic, especially if it's like a really sensitive or a hot topic in the community, something that everyone's talking about. I'm working with a board right now that the superintendent's evaluation has become a very hot topic amongst the community. And I literally saw a board member at the grocery store over the weekend. And I just said hi to him, how you doing? Good to see you. Just did not want to talk about the superintendent because I didn't want to walk them into a Brown Act violation. So these things happen. It seems a little cold-hearted, but if you have that in the back of your mind that I'm really just wanting to be cognizant of what's going on in the Brown Act, people should not get upset. Maybe something to talk about at your next board retreat.
I agree. And so unintentional violations may result from responding to any outside communication because you don't know who else has responded. So just keep that in mind as you go through.
We talk about one-on-one union or citizen discussions. This goes right back to that scenario. A lot of the times your unions, they're your stakeholders, but they're also members of the community. They're going to want to talk to you. They're going to want to talk to you in private conversations. Completely okay to have a conversation. They're your constituents. However, it does get into a bit of a scenario if you have particularly a hot topic going on in the community that you may be inadvertently connecting your mind with other members of the board. So just remember that when you're interacting with members of the public. You can absolutely do so, but just keep that in the back of your head.
All right, so in terms of some requirements when it comes to the actual board meeting, so calling to order, approving the agenda at the beginning of the meeting. So it is possible to add to an agenda that's already existing, but that should only occur in certain circumstances or very rare exceptions where there's an emergency or an immediate need. For example, something that's come up since the agenda has been posted that wasn't reasonably available before that agenda was posted.
Absolutely. And this comes up increasingly with things like natural disasters or wildfires. That was coming up a lot where there was just an immediate need to address something. So increasingly rare, but you can do it.
And reporting out after closed session, any action that was taken or vote and the vote of each member is also required for board meetings as well.
Right, and that's key. Is you can say if an action was unanimous out of closed session, report that it was unanimous. Otherwise, you do have to call out each individual vote.
And in terms of public comments and the requirements there, so the board must allow comment on closed session items before closed session begins, and also must allow comment on open session items at or before the time that the item is considered. And in terms of the regular agenda, so anything that's within the jurisdiction or subject matter of the board, it's a very broad category there, can be addressed on the agenda. And for can be addressed through public comment. And for special agendas or special meetings, only the items that are on the agenda can be addressed through public comment.
That's right. And a lot of times the public doesn't understand that, and they may get frustrated at a special meeting. So special meeting, that's for a very specific issue. The public comment can only be on the special meeting agenda items. Those really broad conversations, that's reserved for the regular meetings. So it may be a point of frustration for some members of the public, and that was coming up a lot during COVID especially, but that's just, it's a Brown Act consideration.
And so some more items about public comment. So it is subject to some reasonable regulation, including the amount of time a speaker has to speak. If there's a translator that's required, you do need to double the amount of speaking time that is set forth in the Brown Act as a requirement.
Yeah, that's something that has come up more frequently. I don't know if it's come up more frequently for you, but a lot of people are challenging that I need more time. And that's just something, again, pulled right out of the Brown Act, like Beverly said.
Right, and don't forget, so there was a case called Baca versus Moreno Valley where you cannot prohibit the public from criticizing employees, criticizing the district, criticizing board members. They have to have an opportunity to criticize if they so choose. However, you can direct a person to the certain complaint procedures that your district or entity has, and you can also remind them of some privacy and defamation laws and direct them to the staff member who can address their concerns or who could take down the information that they are providing.
That's actually a really good way to handle those sorts of items. You know, like Beverly was saying, Baca versus Moreno Valley, it's just there was criticism of a particular person in public comment, and a rule was put in place saying you cannot criticize people. You can't do that. An effective way to handle it is absolutely that, directing person to a complaint procedure. If they start getting into defamatory statements, you can tell them, you know, direct them to a particular staff member for assistance, at which point someone will say, hey, just be cognizant of what you're saying.
All right, so some more on public comment. So individual board members, they should not respond to the matter if it's not on the agenda, but they can respond just to the extent to direct that individual to the correct staff person or staff member, or tell them that they can request a future agenda item.
Right.
And then even during board member comments, so specific matters of business should not be discussed if it's not already on the agenda.
Right, and I don't know if sitting at board meetings, sometimes you'll want to see, like, board members want to get into a back and forth discussion with someone from the dais. That's where you get into trouble, because that may be talking about something not on the agenda. If you're having that discussion, it could be seen as discussing matters outside of a noticed public agenda, which you have to have under the Brown Act.
Agendas must be posted in advance of the meetings, so 72 hours in advance for the regular meetings and 24 hours in advance if those are special meetings. There is the law does allow 1 hour in advance if it's an emergency meeting, and those are pretty rare, so in situations of work stoppage or crippling disaster, for example. And the agenda items that are posted, so they must reasonably apprise the public of the business to be transacted, so the public can determine whether or not to participate. And then it has to have a brief general description, usually no more than 20 words, so not very long. And the agenda materials provided to the board have to become public unless otherwise protected by law. And then the agenda materials provided to the board members within 72 hours of the meeting, those have to be made available to the public without delay.
Right. So going back just to how you're describing agenda items, the example that we like to give is if you have a contract that needs to be approved, for example. Ultimately, the best way to do it is you have a copy of that contract that's appended to the agenda that tells the public exactly what you're approving. But if you have something that just says, like, approve contract for food services and nothing else, no copy of that agenda item, no copy of that contract, rather, that could be where you get into issues. So this 20 words that we say, that's actually pulled out right from the Brown Act. It says 20 words should be adequate for pretty much any agenda item. Just the thing to keep in mind is just transparency. You want the public to be able to know what you're talking about and what you're approving. So if you're using that as a guidepost, that shouldn't steer you wrong. All right, so one of the topics that frequently comes up is, hey, can we discuss this in closed session? So our default baseline rule under the government code, if you just think about this as my default, is that all meetings have to be open to the public and all persons shall be permitted to attend, except as otherwise provided. So think about your general rule. It's an open meeting. That should be your starting point. The exceptions are closed session. So where it says except as otherwise provided, that just means a closed session. What circumstances have to be available before I'm allowed to go into closed session? So the general exception are public purposes for confidentiality. So if there's a reason that something should stay confidential, that's the general baseline rule about how we're able to get items into closed session. For example, public employee discipline. People don't want their dirty laundry aired out in public per se. So that allows the board to discuss an item in closed session without having to disclose it in public. There may be things like negotiations that you don't want public. You don't want it out there what your bargaining position is, right? So that's really the general baseline rule about when you can put something into closed session. We'll talk about some specifics as part of this. We do note a special exception. So this is something that's come up more frequently, at least in my practice, and talking to a lot of our negotiators, they're using this increasingly too. So under the EERA, the Educational Employment Relations Act, it's a separate part of the government code. It's how, what governs negotiations between school districts and county offices and community college districts and their unions. There's a special provision in there, section Government Code 3549.1D, that allows a majority of the board or the entire board to meet and discuss negotiations topics for the purpose of establishing bargaining positions without complying with the Brown Act. So you can have a meeting, not agendize it, not publicize it, if you're using it for that purpose. So that's a very specific example. The public purpose by which you get something into closed session is you want to respect confidentiality. So to that point, there's what we call safe harbor language within the government code, within the Brown Act, that says here are specific items that you can talk about in closed session, and here's some specific language that you can put on your agenda. Because the main thing that we need to be doing with our agendas is putting on the closed session portion what the board's speaking about. So they know that you're not speaking about something that should be open. So this is just a list that we have straight out of the Brown Act that shows what permissible topics in closed session are. So these are kind of the biggies that come up most frequently. I already pointed out public employee discipline, dismissal, release. That's one that you could talk about disciplinary matters. When we say 24-hour notice requirement, that's something where we have to give the employee that we're talking about 24 hours advance notice. And the reason for that is they technically have a right to have their matter discussed in open session. Some people take advantage of that. Have you ever had someone actually do that?
I've had someone request it, but not fully understand what they were requesting.
Right, and then you probably had a conversation afterward, and what did they think they were doing?
They thought it was their due process chance to fight for their employment.
Yeah, and it's really something that I've had the same experience, that people request it, and I've only ever had one person actually go through with it. They don't really just understand. So again, that's just something that's specific in the Brown Act, but other ones that come up often are conference with legal counsel. You're allowed to get legal advice in closed session, and that shouldn't be something that's open to the public. And then lastly, conference with labor negotiators. This is where you can have those candid conversations behind closed doors about your bargaining positions with your unions. All right, so we talked about the safe harbor language. The safe harbor language, the purpose of it is how you're identifying items on your closed session agenda. So these are just some additional requirements that need to go actually on the closed session in order for you to be able to use those closed session items. So these are specific, pulled right out of the government code again. So if you're having conferences with your negotiators or legal counsel, you do have to have some additional information identified on the agenda in order to have a valid closed session. When you're talking about actually appointing employees, so public employee appointment or employment, you have to identify the position title. The one item on here that you do not need to have any additional language on is public employee discipline, dismissal, release. I know in practice a lot of governing boards that I work with at least, they'll put a number of cases or an employee's ID number. You do not have to do that. You just have to put public employee discipline, dismissal, release. Then lastly, conference with labor negotiators. You have to identify who your negotiator is as well as the organization. We've talked about like what we're allowed to talk about in closed session, but Beverly, what's the whole point of the Brown Act? Like what is the purpose of trying to be transparent with the public?
I mean, to conduct district business, of course, but transparency is key.
Right, and that's kind of the main thing we think about with everything. So closed sessions are exception to that general rule, but there are some transparency requirements that we have to have as a result of closed session. And so here's really the big points to hit. So if you're taking action in closed session, you have to report out all of that action or activity. There are some exceptions. The big one being things like settlement agreements. If the board is the last party to approve a settlement agreement, you do have to report it out and report out what the votes were and the substantive terms of the settlement agreement. However, if you're not the last party to sign, say the other side has to sign it, you don't have to report it out at that point. So that's where we say that there's some exceptions. But in general, the board's going to be taking final action on something in closed session. They have to report out what action they took as well as their individual votes. unless it was unanimous, in which case you can say the vote was unanimous. And that kind of gets into our next rule right there. You have to report or record the individual vote of each member. So say it's a 4-to-1 decision, you announce the 4 yes votes and the 1 no vote. So keeping that in mind, sometimes that will affect how people vote. A lot of the times when we have things like approving agreements, we want to show a unified front. So that's just something to keep in mind if you're going to vote against it, that your vote may have to be reported out. It's going to have to be reported out publicly. With employment contracts, one of the items that we talked about in safe harbor language, you could take action to appoint a specific person in closed session. So you want to appoint a brand new superintendent. You can absolutely appoint that person in closed session. However, you have to approve their contract in open session in a regular meeting. It's something that's not recent, but it's been something that's been on the books for 7 or 8 years now, is that you have to be reporting out, voting on that employment contract in open session and reporting out the substantive terms of that agreement. That's, again, something right in the government code 54953. It talks specifically about that oral report. So you cannot have a discussion of salaries and benefits in closed session, except conference with labor negotiators. So when we're talking about labor negotiator, you're talking about your unions, your represented employees. You can keep that confidential. You don't want to put your bargaining position out in the world because that kind of makes things useless, right? However, if you're talking about specific salaries and benefits, you cannot be having those discussions for contract employees. So like your executive cabinet, your superintendent folks. You cannot be having that conversation generally. You can have that conversation if you identify your agency negotiator as well as a specific title. So if you had, say, Beverly Ozawara as my specified representative to negotiate with a brand new superintendent, you can absolutely have that conversation if it's identified in closed session. No discussion of compensation in a special meeting. So this is something that we kind of forget about a lot of the times. If you're talking about executive compensation, that has to happen in a regular meeting now. And then another one that, just lastly, I think most everyone's in compliance with at this point, but something that changed recently in the Brown Act, your agenda has to be posted on your website, on your front-facing page, single click. So Board Docs, I think, is the company that a lot of us use now. They have the ability, if you have something on your web page, you click, it takes you right to the current agenda in Board Docs. That's because that's now a requirement under the Brown Act, single click agenda. All right, so we mentioned at the top when we were running through our agenda that there were some specific penalties that may be associated with Brown Act violations. We don't necessarily like talking about them, but we just want to make everyone aware that they're on the books. And sometimes people have gotten in trouble for violating Brown Act. And specifically the main way that they do is violating confidentiality. First, we're going to talk about challenging a board action, and this is really if someone, a member of the public or the district attorney, says that an action taken by the board was in violation of the Brown Act. There is a mechanism within the Brown Act that allows them to do that, and that's basically through the submission of what's called a cure and correct letter. So what happens if action is taken in violation of the Brown Act is someone, a member of the public or the district attorney, will send a demand to cure and correct to the board saying, hey, on January 1st, you violated the Brown Act by approving an executive contract in closed session. At that point, the board can either take voluntary action to fix that mistake, or they can tell that person no. If they tell that person no at that point, that person could go to court and get some sort of court order forcing you to take action. But basically the point of it is that under the Brown Act, the board is given an opportunity to cure and correct a deficiency. So from time to time, we'll get a cure and correct letter. Sometimes we'll say, yeah, you know what, you're right, our bad, we'll go ahead and correct. Sometimes we'll say, no, we don't agree, and then we'll move forward. But the whole point is that it gives an opportunity to the board first to correct their mistake. So the whole purpose is to either prevent future actions from occurring or remedying past violations. I actually just got a demand letter a couple weeks ago from someone saying, hey, it's I've been made aware that there's been conversations amongst a majority of board members about the superintendent's contract. You better not be taking that action at the upcoming meeting. And lo and behold, there was something that happened outside of the Brown Act, and we said, you're right, we're not going to take any action. So that's the whole purpose, to prevent either future actions or remedying past. So the big one on the books about individual penalties. So we're talking about, penalties towards the board, how you challenge board action. Individuals can actually get in trouble under the Brown Act, and people kind of sometimes get surprised at this, but there's a confidentiality provision. So anything that was acquired in terms of information in closed session as a result of being present in closed session, you cannot disclose that information to anyone not entitled to receive it, unless the body authorizes that disclosure. So say I'm in closed session and we're talking about this beautiful piece of property that we're going to get, that we're seeking to buy. And there's some issues associated with the broker. And if I learn that only in closed session and I release that to the public, then technically I violated the Brown Act. And that can carry with it either injunctive penalty or referral to the grand jury. And you can actually be held to be in violation of the Brown Act. It's actually a misdemeanor. So you can be imprisoned up to 6 months for that. Although I don't know anyone who's been in prison for a Brown Act violation, do you?
I don't either.
No, I don't think it's ever happened, at least in my practice. But it is a crime that's on the books.
Now on to our Brown Act hot topics. So we'll go through several hot topics, starting with disruptions and the SB 1100. We'll talk about remote meetings, social media, some case law there, public agenda item requests. We'll talk about some anticipated litigation in closed session, when that's listed on the agenda and what that means with the case law, conferences and the meeting exception. We'll also talk about the EERA meeting exception, and then discussion and action on executive comp. So let's go through each of those. In terms of disruptions, so SB 1100, that added to the government code and was effective as of January 1st of 2023. So there was already existing law and typical board policies prohibiting disruption and allowing for removing people who are disruptive during board meetings, with some limitations, of course. But when this Senate bill came in, so it provided additional statutory authority and guidance for presiding officers of the legislative body to remove disruptive attendees. But before a person can be removed, that person who's being disruptive, they have to be warned that they are being disruptive, and if they don't stop doing that, they will be removed. So if they continue to engage in that action, this new law or change in the law allows them to be removed. So then in terms of disrupting, so what does that actually mean? That's behavior, of course, that disrupts, but also disturbs, impedes, or renders infeasible the orderly conduct of the meeting. There's so many different examples of this, but this can include failure to comply with reasonable or lawful regulations of the body, or failure to comply with the law, engaging in behavior that constitutes use of force, or a true threat of force. That's another example as well.
So I don't know if you know this, but part of the legislative history for this Senate bill had to do with a lot of the disruptions we saw in COVID.
Right.
So that was one of the big things that really pushed this. And I don't know if you remember in Poway Unified School District, maybe 2 or 3 years ago, they shut down completely a meeting. They found out after the fact that a lot of people actually were paid to do that. They were actually like bussed in from another county. But it gives more teeth to the governing board's ability to actually have these folks removed. So thankfully it's a little bit easier now, and it came up more and more during COVID, unfortunately.
Right.
Yeah.
In terms of remote meetings and Assembly Bill 2449, so the Brown Act contains traditional teleconferencing rules, which includes identifying the remote location and posting the agenda there and holding that location open to the public. And then there's Executive Order N2520 that added the option during the pandemic. So meetings can be fully remote during state of emergency, provided that the public is given electronic means of observing and participating in that meeting. And AB 2449, so that amended the Brown Act to allow less than a majority to participate remotely without complying with those traditional rules that we think of. if there's two circumstances that are occurring there. So one being just cause, the other being emergency. So just cause, like caregiving situation arise, an illness, disability, travel, those sort of reasons. An emergency, so like family or personal medical emergency, but the board member would have to describe what is going on there. And the majority must participate from a single physical location that still remains open to the public, and then must provide two-way audiovisual access to the public in real time as well. Those are the requirements.
So just a couple of quick notes on this one. With the personal or family medical emergency and having to briefly describe it, there are privacy laws that allow the board member not having to describe specifically a medical condition or anything like that. If you identify, basically I'm absent because of a medical emergency, that should be sufficient. But you should consult legal counsel, of course. And then secondly, one of the items that comes up from time to time is two-way audio-visual access to the public in real time. Questions come up, can I have my camera off? And actually there's technically a component within this brand new assembly bill that suggests, and we've opined that, yes, you have to have your camera on. It allows the public to be able to observe you visually as well, and also ensures that there's no other people in the room potentially. So in any event, that's just something that's nuanced that's come up.
In terms of social media and hot topic there, so there's Assembly Bill 992, which was effective as of January of 2021 and goes through January of 2026. So that authorizes individual board members to engage in conversations with the public via social media, answer questions, provide information, or solicit feedback from the public. And board members, they cannot use social media to discuss among themselves business that's within the subject matter jurisdiction of the legislative body. That remains the law, that's still consistent there. That includes comments and also use of digital icons as well. So icons that are expressing reactions, communications made by other members of the legislative body, like emojis, the like button, the happy face, those sort of reactions.
So be careful what you like on Facebook, essentially.
Yes. And in terms of a case, so the Garnier versus O'Connor-Radcliffe case, hopefully I said that correctly, board members may not block or restrict the public from social media on a viewpoint basis. And so there's a whole First Amendment analysis in that case, and also a discussion about qualified immunity issues. But there can be some reasonable content restrictions in limited public forum, but not a blanket ban on individuals from being able to engage with that board member or participate on their social media page.
Right, and a good way to think about that is that Baca versus Moreno Valley case from a while ago. You can't delete someone's comment because they were critical of you. Now, if they've said, a swear word or something like that violates other restrictions, sure, that could be censored. But this really gets back to the whole point about you got to take the good with the bad. Exactly.
And also in terms of public agenda item requests, another hot topic there. So Education Code Section 35145.5, such a mouthful there, but it allows the public to place matters on the agenda of school district board meetings. So this is a recent development where the public is demanding discussions, action, or consideration of proposed resolutions of board policies. So the public can add items to the agenda. And so if you're faced with that situation, there's several strategies, directing the public to use public comment, if necessary, using a discussion item entitled public request for agenda item, that can be there, but keep it strictly to a discussion item only. And the public can't make or compel the board to consider an action or a resolution. This is the equivalent to a motion, so only a board member can make a motion. That's still the law. Mm-hmm. But proposed policies and resolutions, those should be vetted by staff and or legal counsel, so just keep that in mind so we're not having the public add in the proposed policies and things like that.
Right, and that's been something that has popped up more recently. You'll have these national or statewide organizations propose a resolution for the board to pass supporting or opposing a particular viewpoint. That should always be vetted through staff and legal counsel. You're of course permitted to consider and adopt those sorts of resolutions, but they have been pushed as something to demand be put on an agenda and demand to be adopted or considered. That's something still within board authority that you can absolutely consider that, but it is board motion and your authority as board to collectively decide whether or not you want to support or pass that resolution. With our closed session agenda items, so going back to this discussion that we had earlier about how you identify certain closed session items, we're going to discuss a case, this Fowler versus City of Lafayette. It kind of restricted our use of a particular agenda item for discussion of anticipated litigation. So you are allowed to have a closed session meeting with your legal counsel to discuss potential litigation. So this is something, someone has made some sort of remark, you've seen received some sort of demand, there's been some sort of circumstances where a lawsuit's not yet been filed, but you're anticipating that one may be filed. So you can absolutely have those discussions in closed session. You have to identify the number of potential cases, but you don't have to identify who those potential litigants are, who potentially the people bringing the case or defending the case are. However, this newish case, Fowler versus City of Lafayette, came up in 2020, and it's been coming up increasingly with people who make demands, public demands, or public threats of litigation. So in this particular case, someone made a threat in a letter that was given to the entity, but as part of the consideration in closed session, that letter was not made available to the public or put in the agenda. And so someone challenged that action as impermissible closed session action because they didn't provide that. What the court ended up saying was that the failure to identify the case or any of the facts or circumstances related to the threatened litigation and failure to provide that document as part of the agenda packet, that was a Brown Act violation, where the city council in that case discussed the litigation threat in closed session, but did not make that document available. So that was considered a violation. I do want to say the facts in that case were pretty narrow, and that involved a very narrow part of the anticipated litigation closed session exception. So it only applies where notice of the potential litigation was provided to the agency in writing outside of a board meeting. So if your agency gets any sort of written communication that's not like a tort claim or a government code claim on your form, you should get with staff, get with legal counsel to determine, do we need to be providing this as a public document in order to discuss it in closed session? There may be other ways to discuss it in closed session, but just be aware that this is a new case that came out challenging that specifically. Okay, so we've already kind of touched upon this, but we talked at the top of the hour, what's a meeting? What constitutes a meeting? What are exceptions to meetings? So just to give this to you as, we're not saying that you can't ever be with one another, that, a majority of you can't ever socialize with one another. We wanted just to make you aware that there's meeting exceptions that allow you to be together without having to agendize a meeting. So again, we're just highlighting conferences and similar gatherings open to the public like CSBA. Please don't feel like you can't attend those conferences. You can be together attending those gatherings that are open to the public generally, where you're receiving really education on how to be a better board member. So open and publicized meetings that are organized by another organization or agency, like CSBA, like any of the other statewide agencies, CASA, CALSA, any of the statewide agencies that are for administrators or board members, feel free to attend those. You don't have to feel like you need to be agendizing anything. Separately, purely social or ceremonial occasions, you don't need to be agendizing that. And that comes up every single year during graduation season. That's a celebratory time that you can all be together. So long as you're not discussing specific district business, you don't have to agendize a graduation ceremony. Less than quorum social media interactions, and we say take care because this provision sunsets in 2026. That's what Beverly was talking about earlier, the AB 992. The only thing to keep in mind is that in each case, like I said, a majority or quorum of the members cannot discuss specific agency business. All right, this one, we already touched upon this as a big exception to the Brown Act that not a lot of people know about, although I think more and more people are becoming aware of. So under the Educational Employment Relations Act, there is a limited exception that allows closed session meetings without complying with the Brown Act at all, for allowing the agency to discuss your position regarding any matter within the scope of representation and instructing representatives. So for us, K-12 schools, that's specifically in the government code, as well as community college district and county offices. We used to refer to this as the super secret EERA exception, but like I said, it's being used increasingly more and more, so I don't think it's really that much of a secret anymore. But for example, if you needed to poll other board members on a specific bargaining position, say you're getting down to it, you're at impasse and you're wanting to maybe avoid a strike, there's nothing preventing you as the board president or a board member from calling all of the other board members to talk about, are we going to accept the union's last, best, and final offer? It's permitted under the Educational Employment Relations Act. So just something to keep in mind when we're talking specifically about bargaining. Okay, and then this is more a refresher than anything, but it's something that has really come to the forefront in the last 5-6 years or so. Executive compensation. And so early as a result of the City of Bell scandal that came out about 10 years ago, there were these big reforms to the Brown Act and how we talked about executive compensation in a way that was as open and public and transparent as possible. So what the Brown Act provides is that you cannot have discussion and action on local agency executive compensation, including fringe benefits, in closed session. And what that basically means is executive cabinet and higher. So anyone in executive cabinet and your superintendent. So those conversations, approval of compensation and fringe benefits, can only be addressed at a regular meeting. You can't hold a special meeting for it, unfortunately. Your closed session discussion can also only occur under that safe harbor language, conference with labor negotiator, unrepresented employee, and then providing the title of that person. So you can have that conversation in closed session at a regular meeting, so long as you properly identify it. Separately though, if you're going to approve a contract, it has to be at the regular meeting in open session. So that has to be a standalone open session item. And that includes any changes to salary or benefits or any renewals or term extensions. So think about any time I'm changing something in an executive contract, I have to be doing that at a regular meeting and I have to be doing it in open session. The board vote also has to be preceded by an oral report describing the financial terms. So what that typically, with legal counsel will be is some sort of script identifying all of the high points about what sort of salary and benefits are being given to that executive and must be read out prior to the item being voted on. So again, just a nuance that comes up from time to time. The consequence of not doing this is that it actually voids the contract. So it's a big deal. And I've seen penalties where money actually has to be returned by the executive to the agency because it was not properly agendized and reported. Under the Brown Act, no, you don't need to be following Robert's rules. However, you want to be checking your board bylaws because a lot of the times your board bylaws will incorporate Robert's rules as how you conduct your business. So your meetings should be conducted in an orderly operation, and Robert's rules typically ensures that. However, just be cognizant in your board bylaws, it may be required, and in that case, there may be a discussion about which version of Robert's rules has to be required. And so that may require an update to your board bylaws as well if you're using an older version of Robert's rules. But again, not a requirement under the Brown Act that you have to use Robert's Rules of Order. So typically from a boardsmanship perspective, that's something that's really reserved for district staff. And depending on what level the complaint comes in about a district employee, that should be directed to the superintendent. Individual board members don't have the ability or the power to directly address and handle complaints. You're certainly permitted to listen. These are your constituents. You're permitted to listen, address, and talk to members of your staff in order to address and correct these problems. However, there are limits to individual board member authority where if you go outside of the lines to try to address these issues, it may become an issue where you're acting outside the scope of your power. Under the Education Code, the board acts by the majority. Sometimes if you're board president in particular, you may get specific complaints or requests, but those are best directed to either the superintendent or the appropriate cabinet level staff member whose department may be able to handle that.
I would say so. Yes, you can, but cautionary tale, because when you have multiple board members commenting, you could inadvertently have a serial conversation meeting that's occurring, right? So just as a cautionary tale, I would recommend against that.
Right. I know that there's a lot of pressure to comment and be involved and active. Social media is probably not the best place to do it for that very reason. You can absolutely take into considerations, but in terms of actively making comments, that could walk you into trouble. And with the AB 992 laws that are currently on the books till what, 2026, right?
Right.
That could be walking you into a situation that you weren't necessarily intending. No, I would say that that's something that is best reserved to something like a board study session. Board study sessions, board retreats, those are all noticed Brown Act meetings. And frankly, members of the public don't really attend those. However, if you're talking about specific district business, which includes identifying a vision or objectives, then that is absolutely something that should be occurring as a public conversation. Again, I think I've seen in practice and most effectively done at things like board retreats. And not saying you have to have a board retreat, but that's typically, you know, as a retreat or a study session, a great time to be doing that. Maybe also checking your board bylaws. Sometimes you're required under those bylaws to be having those meetings, regularly or at least annually, to be developing those sorts of goals and helping to really reach that vision.
So this kind of goes back to one of the questions from earlier. So in terms of redirecting that back to maybe your superintendent or to another individual who can then direct that staff member, and just maintaining kind of that separation is generally a favorable approach.
Right. I'd like to preface this by saying, if you think as a board member and as the board, you really have one employee, and that's your superintendent. Once you start getting into situations where you're visiting school sites and directing individuals who aren't your direct employee, that can get you into some issues, both from a governance perspective, as well as sometimes I've seen it come up where those sorts of conversations could lead to individual complaints by employees against the board member. I think things are best handled if there's concerns. You can absolutely visit a site as a board member. You're a member of the public, you may even be a parent. You can absolutely interact with people. Where you get into issues is if you do start directly identifying and directing employees how to do their work. You can absolutely bring up those concerns to the superintendent and follow up to see that they're being addressed. But you do get into situations, I 100% agree with Beverly, where that could be problematic. I've had this question come up time to time. I don't know if you've had with individual board members wanting to look at personnel files, but I take the position that an individual has a right to privacy in their own individual personnel file and that information. If, of course, an individual permits someone to look at their personnel file, and I've had this happen with board members, that's something that's permissible. An individual can always give their permission to. However, as an absolute right for a board member to go into personnel files, I take the position that that's not something outside of employee consent that an individual board member has a right to. Individual district employees, they have the right, depending on which department they're in, to look through personnel files. But individual board members, I say absent consent, I advise no. So abstentions are always a bit tricky because sometimes we have board members who want to abstain for political reasons or just any other personal reasons. The California Attorney General, as well as a lot of board bylaws, have opined that board members have an affirmative duty to vote on something absent some sort of conflict of interest or other action that prevents them from voting. So abstentions as a typical rule, and you can review your board bylaws because most of them have it within, is that there's an affirmative duty to vote on every item that comes up and that you shall not abstain unless a conflict exists. If it's determined that you may have a conflict, there's various levels of conflicts, and this is something that you should be talking about with legal counsel. Sometimes there's personal conflict of interest, sometimes there's a legal conflict of interest, sometimes there's a financial conflict of interest. Depending on what kind of conflict, you may be even prevented from participating in the discussion of a certain agenda item. So it's always best, if you feel that you have some sort of conflict, to contact your superintendent or the board president to determine if legal opinion should be given. And in that case, you can be directed on whether or not you should abstain from voting. But as a general practice, as it's seen through both board bylaw and attorney general opinions, there's generally an affirmative duty to vote on every item, absent a conflict. All right, so thank you for your time this evening. I know that the Brown Act can be a bit dry at times. It's something that we're all thinking about constantly as board members, probably the set of laws that is at the forefront of our minds most. There's a lot of little tips and tricks that we're able to use and be thinking about in order to avoid trouble. So I hope you were able to gain something from tonight, maybe learn something new that you hadn't thought about previously. But as a general rule of thumb, just keep in mind that if you're conducting your business in an open, public, and transparent way, and you're keeping your conversations to those public meetings, typically you're going to keep yourself out of trouble. So thank you for being with us tonight. We appreciate your time.
Thank you, everyone, for joining us for our presentation, for being with us here this evening. And in terms of the presentation, of course, we couldn't cover every single nugget related to the Brown Act. So we do hope you took away some good takeaways, and you can refer back to the PowerPoint slide in this presentation at a later time as potential issues may arise. So thank you so much, everyone.
There you have it, the Brown Act. What you don't know can hurt you. On behalf of San Bernardino County Superintendent of Schools and the San Bernardino County School Boards Association, I want to thank our two attorneys and our partners at the Inland Personnel Council for this timely and appropriate training. For those interested, the slide deck is available for download in the description below. Now, we want to hear from you. Please take a few minutes to complete our evaluation in the description below. Your valuable feedback helps us to better plan for future events. Again, thank you for joining us. These types of workshops allow us to continue transforming lives through education.